Thank you. Good evening. Thank you. Welcome to everybody. First of all, my good wishes to all the participants who are going to compete for the examinations for the posts of member, the State Dispute Consumer Redressal Forum, and the President of the District Consumer Forum. I've been asked to speak on the various topics from the Constitution, and I've been given the syllabus which you are supposed to be acquainted with. Now, that almost covers the entire Constitution, and it is really impracticable and impossible to cover the entire Constitution in a span of 30 to 45 minutes. But I will give you in capsule the issues which you ought to address yourself for preparation for this paper on constitutional law with various chapters which you are supposed to be acquainted with. I'll give you a little background of the Constitution and then introduce the key issues to you. First and foremost, you all possibly you remember, but you need to remember the Constitution was the first document prepared by the Constituent Assembly. But before that, when India was under the British rule, there were a series of acts under which the governance of the country was controlled, and those laws were passed by the British Parliament. The last of such law, which was passed by British Parliament, was Government of India Act 1935, which operated in India from 1937 till 1950, when the Constitution came into force. Under that act, there was a federal assembly like we have a parliament today, and there were provincial assemblies like we have the state legislatures, which consist of state assemblies and legislative councils. So there were elections periodically held to the federal legislation as well as the provincial legislations. The last elections were held in 1946 to these assemblies, federal as well as provincial, and the members were elected to these federal and provincial assemblies. They constituted themselves into what is popularly known as Constituent Assembly of India. That assembly started functioning with a job of framing of constitution from 1946, and they concluded their job on 26th of November 1949. So that is the day we celebrate as Constitution Day. And thereafter, the entire constitution came into force on 26th January 1950. Now, why the Constitution was deferred till 26 January 1950, there is a historic significant event. If you remember, those who are students of history will know this. On 26 January 1930, the Congress committee had held its session at Lahore, and they had declared and passed a resolution to acquire and gain Purna Swarajya. So therefore, 26 January had a great significance. And therefore, although the Constitution was adopted on 26 November 1949, the Republic came into force on 26th of January 1950. The first important part of the Constitution, which is framed by those illustrious forefathers of our Constitution in the Constituent Assembly, is the preamble. Preamble is the key to what the Constitution is, what we are going to associate ourselves into, what we are going to constitute ourselves into, and what are our goals and objectives. Therefore, the preamble begins with the important words known as "We the people of India." So this constitution is prepared by we the people of India for ourselves. So if you read the grammatical sentence of the preamble, it says, "We the people of India are doing the following, and we adopt, enact, and give to ourselves this constitution on 26th of November 1949. So we the people, that is the representatives of the people, have given this preamble and this constitution. So the importance of preamble is why the constitution is made, what is the object of the Republic of India, what is it supposed to achieve. And in that, you will, if you look at the preamble of the Constitution, it says we are constituting ourselves into a democratic, sovereign, democratic republic. So these are three important phrases: sovereign, democratic, and republic. So we are constituting ourselves into a sovereign, so we are not subjected to monarchy anymore. We are going to be democratic so that people will have representation, And therefore, there is a concept known as universal adult franchise, which means the moment you become adult, you are entitled to participate in the electoral process. Now, several of you might know this universal adult franchise concept was adopted in India from earlier also in 1935 also, but Constitution gave recognition to that. Several European countries, including in US, UK, etc., women did not have right to vote. So there was no universal adult franchise, and we had that from the beginning. That's the greatness of our Constitution. So the Constitution is for establishing a sovereign democratic republic. There were two words added in this phrase in 1976 by way of 42nd Amendment. And now we are saying that we are going to establish ourselves into sovereign, secular, socialist, democratic republic. So these two words, secular and socialist, were added in the Constitution by 42nd Amendment Act in 1976. Of course, the sovereign, the principle of socialism and secularism was already there in the Constitution, which I will tell you a little later where that principle is. But the principle of socialism and secularism was already there in the Constitution, which was also brought in forefront in the Constitution. So that's the first purpose, that we are establishing ourselves into a republic. The second purpose of the Constitution, which is set out in the preamble, is to secure to its citizens justice, and justice of three kinds: social, economic, and political. So that's the object of the Constitution, which is set out in the preamble. Then we have also to establish equality of status and of opportunity. And then we are supposed to have fraternity amongst individuals, ensuring dignity of the individual and unity and integrity of the nation. So that's broadly the preamble of the Constitution. I think I used to tell the students when I taught the constitutional law in the law colleges that there are two parts of the Constitution which you all must learn by heart. The preamble is the first part, which you should always remember and learn by heart, because that's the objective, that's what the entire Constitution is. In fact, the preamble considers and preamble summarizes in a précis way what the entire Constitution is. So all of you should remember these key phrases in the Constitution. And since you are preparing for an examination, these key words, key phrases would be very, very useful if you remember the preamble by heart. And no harm in even the practicing lawyers remembering the preamble by heart. Not only it is good for students, but also for the practicing lawyers. So that's the first part of the Constitution, which is part of your curriculum. The next topic which is related is the chapter on chapter 3, part 3 of the Constitution, which relates to fundamental rights. Now, when I told you that before 1950, we had Government of India Act 1935, the major constitution is borrowed from Government of India Act 1935. Part 3, which is the fundamental rights, that is borrowed from what is known as Bill of Rights in American Constitution. So our fundamental rights are equivalent to Bill of Rights in American Constitution. And part 4, which is the Directive Principles of State Policy, is borrowed from Swiss Constitution. And rest of the Constitution is modeled on Government of India Act 1935. So fundamental rights can be classified into 3 or 4 categories. First and foremost, against whom the fundamental rights are available, that is, which are contained in part 3. For that, you need to understand the concept of state, which is defined in Article 12. The rights are available against the state, and the state has been defined in Article 12 to mean the executive of the union, executive of the state, the legislature of union, legislature of the state, and all other authorities and instrumentalities which are controlled by the government or the state government. Now, this concept of authorities has been interpreted by a series of decisions of the Supreme Court to expand the scope of that authority. And finally, what you can remember is that any authority which is under the control of the Union of India or the state government, which is financed by these authorities, which has a managerial control by the state or the central government, etc., they all will be considered as state for the purposes of Article 12. And against such an authority, the fundamental rights guaranteed under Part 3 can be enforced. you can remember few judgments on the aspect of state. The Supreme Court has laid down various tests to find out whether a particular authority is state or not. One of the important judgment you remember is in the case of International Airport Authority of India, that is R.D. Shetty versus International Airport Authority of India. Then there is another judgment in case of Ajay Hasia's case, Brojanath Ganguly's case. There are series of judgments. I think the Bar Council will be circulating a note for all of you. You will get those cases in that note. So that's the first thing you remember. The second important aspect about fundamental rights is concept of law. What is law? That is defined in Article 13. So law includes not only the law passed by the state legislature or the central legislature, but it also includes rules, regulations, bylaws, subordinate legislations, notifications, government resolutions, government GRs as we call them, or government orders, everything. So whatever controls your rights, whatever affects your rights, whatever is the decision of the government, that would be considered as a law for the purposes of Article 13. And why that concept is important is because Article 13 also has a mandate that states shall make no law which violates any of the rights conferred in Part 3 of the Constitution. So that's very, very critical concept of law. So we have concept of state, concept of law. Then we have actual fundamental rights, which can be classified into 3 or 4 categories. The first right under the fundamental rights is right of equality, for which purpose you need to study Articles 14, 15, and 16. Article 14 is one-line article which says that the state shall not deny to anyone equality before law and equal protection of laws. But before I deal with that, I must tell you one more thing. Several fundamental rights are available only to citizens, and several fundamental rights are available to any person. The moment you are on Indian territory, you will be entitled to have fundamental right. You will be entitled to enforce that fundamental right. So Article 14, which is the right of equality, is available to everybody who is in Indian territory, regardless of the fact whether he is citizen of India. So right of equality under Article 14. And Article 15 is in respect of public employment. So in public employment, the state is entitled to give preferential treatment to scheduled caste, scheduled tribes, and other backward classes, because these are all provided now in Article 15. And Article 16, sorry, that is in Article 16. Article 15 provides for special provisions can be made for women and children. So though Article 14 on one hand has right to equality, Article 15 and 16 are kind of exception to a general rule that there shall be general equality, but there can be a special treatment in favor of women and children under Article 15, and in favor of scheduled caste, scheduled tribe, and other backward classes, economically weaker sections of the society, that is provided in Article 16. So that's right of equality. Now there are two other articles, two other rights. One is abolition of untouchability and abolition of titles. That is under Articles 17 and 18. So that is also to bring the society at large and bring it at par. Everybody should be brought at par, and that's the concept of equality. So these are the 5 articles which deal with right of equality. Then we have another important article, Article 19, which guarantees 6 freedoms. Earlier there were 7 freedoms. One of them was in relation to right to hold and acquire and hold property. That has been deleted in 1979 by 44th Amendment Act. So now we have 6 freedoms which are available only to citizens of India. And those 6 freedoms are freedom of speech and expression, freedom to carry on business, freedom to assemble peaceably without arms, freedom to move throughout the territory of India, and freedom to form associations. But these rights are available only to citizens of India. That is the declaration in Article 19. These rights can be, reasonable restrictions can be imposed on these rights, which are prescribed in Articles 19.2 to 19.6. So for you, you should remember, these are the 6 freedoms guaranteed under Article 19, and there can be reasonable restrictions put on these freedoms under sub-articles 2 to 6 of Article 19. So those are the 6 freedoms which you should remember. So that's another article you should remember by heart, so that you know all those 6 freedoms which are guaranteed to the citizens. The third set of rights which is guaranteed is in case of personal liberty, for which you have Article 20 to 24. Article 20 has 3 concepts and very, very important concepts which you should remember. The first is right against the double jeopardy, which means no person shall be prosecuted and punished for the same offense twice over. That is known as doctrine of double jeopardy. The second aspect under Article 20 is that nobody shall be forced to The second facet of Article 20 is that nobody shall be forced to give evidence against oneself. So that rule is known as no law against self-incrimination. You can't be asked to give evidence against yourself in criminal trial. That's the second facet of Article 20. And the third facet of Article 20 is there shall be no retrospective penal law, which means that today you cannot be told that what you did 2 years back is an offense. Offense must be defined by law, and that must be offense on the day of commission of a particular act. So these are 3 very, very important aspects of Article 20 in case of personal liberty. Yet another important article is relating to personal liberty is Article 21, which mandates again a simple one-line article which you all should remember by heart. No person shall be deprived of his personal liberty save in accordance with procedure established by law. That's Article 21. This article is available, Article 20 is available to anybody. You don't need to be citizen for that. So you might have a question, which are the fundamental rights which are available only to citizens and to any other persons? So right to equality, which I told you under Article 14, personal liberty under Article 21, the 3 principles of personal liberty under Article 20, they all are available to anybody. The moment you are in Indian territory, these rights are available. What is most important about Article 21 is it's a one-line article. It has not been amended at any point of time, but the Supreme Court has interpreted this article, and the High Courts also, from 1950 till today, and particularly after 1978, to include every facet of life which is required to make human beings' life meaningful and important. So anything which is required for human being is read as a part of personal liberty. And I will give you a few examples. Good roads, good environment, good clean drinking water, non-polluted air, proper planned cities. These are all facets which are read into Article 20. So personal liberty has been expanded by the courts to such an extent that anything which is required for a human being to have a meaningful, a proper life is read into Article 21. So that's very, very critical article in relation to personal liberty. There are a large number of decisions which you will find in the note, and a particular species of right which has been read as right of personal liberty by the Supreme Court and the High Courts. You will find those judgments in the note. So you can remember few of them, few of the facets of personal liberty under Article 21. Another important article is in respect of preventive detention, and that is Article 22. So you might be asked a question, what is the right of a person if he is detained under the preventive detention law? That is provided in Article 22. And there are 2 basic rights. The first and foremost, such a person is required to be produced before a magistrate within 24 hours. That is 1. And 2, if the person detained in preventive detention is required to be referred to the advisory board constituted, which is headed by a sitting High Court judge. And within 90 days, that board has to give an opinion for confirmation of the preventive detention, or if the board does not confirm the preventive detention, the person has to be released from preventive detention. That's law relating to preventive detention under Article 22. So you might have heard about the laws. There was a very, very famous or infamous law known as MISA. Maintenance of Internal Security Act during emergency. That was a law with reference to Article 22. Today we have National Security. There was another act known as National Securities Act. That was also a law referable to Article 22. Then in respect of personal liberty, there are two more articles, which is Article 23 and 24, which provide for that there shall be no bonded labor and children will not be permitted to be allowed to use in factories which are hazardous, etc. So these are two important rights, again, in respect of personal liberty of the persons. They are again available to every person, regardless of the citizen, whether a person is citizen or not. Then we have important right, religious freedom under Article 25. So you have the freedom of religion, which includes right to practice, profess, and propagate your own religion. Of course, not against anybody's wishes. You cannot force, and that's why the forcible conversion is not permissible. You can practice your own religion. If you want to propagate it, you can propagate it without forcibly enforcing it upon anybody. That's guaranteed right under Article 25. But of course, there are certain exceptions such as public order, etc. So therefore, the provisions like Devdasi or Sathe, etc., were prohibited. And even though some people claim those to be religious practices, and some people said that you should be allowed to practice them because it's a part of the religion, Article 25 allows the state to prohibit certain activities, even though they are religious, if they are against public order, health, or morality. Then we have very important article under Article 29, which is the right of culture. So you are entitled to preserve your script, language, and culture. And for that purpose, you are entitled to profess, you start your institutions, etc., cultural institutions, etc. So that's the right of education, culture, and script, language, etc. And another important article is Article 30, which is the minorities' right to start, establish, and administer educational institutions. So this right under Article 30 is conferred upon minorities. Minorities are of two kinds, religious minorities and linguistic minorities. So for example, in state of Maharashtra, all other languages except Marathi language would be considered as linguistic minorities. And all other religions except Hindu religion would be considered as religious minorities. So if you belong to that particular category, you can establish, administer, and manage your own educational institution, and state will not interfere with that. Of course, the latest judgment of the Supreme Court in TMA Pai Foundation case has stated that the state can regulate it, state cannot discriminate it, and state will not interfere with the management, but state can prescribe the standards of education as well as standards for appointment of teachers, etc. But they will not interfere with the management and appointment procedures, etc. So that's an important right guaranteed under Article 30 of the Constitution in respect of religious minority institutions. Now, when I talked about concept of secularism, that concept was always there in Article 25. And the concept of secularism has three facets, which is the state will have no religion, the state will not support any religion, and state will not discriminate between the religions. These are the three facets of secularism. So if you are asked to write a question, answer to the question on secularism, these are three important facets of secularism. And that was always there in Article 25 and 26. So when I mentioned that the word secularism is added in the preamble, it was always there as a part of the Constitution. It has been brought in forefront in the preamble. And Article 32, the most important article, which is right to enforce the fundamental rights by approaching the Supreme Court of India. So if anybody's right is violated by the state, you can go to Supreme Court under Article 32 to enforce that fundamental right. So Article 32 to enforce the fundamental right is itself a fundamental right. And Dr. Ambedkar during the Constituent Assembly debates had said that if you ask me a question, which is the soul of the Constitution, he said, without hesitation, I would answer that by saying Article 32 is the soul of the Constitution, because that guarantees not only the fundamental rights, but also guarantees the right to enforce those fundamental rights by directly approaching the Supreme Court of India. So these are broadly the fundamental rights enshrined under Part 3 of the Constitution. And as I mentioned, these are modeled on the basis of Bill of Rights from the American Constitution. Now, the next topic which you are supposed to be familiar with is the directive principles of state policy. And I'm told you already had a discussion, so I'll come to that later if I have sufficient time for that. In that, I want to only mention two or three things. Directive principles from Article 38 to 51 are the basic guidelines, what the state is supposed to achieve, what the state is supposed to work for. For example, Article 39, which says that the state shall administer its economy in such a way that there is no concentration of economic wealth in few hands, or state shall ensure that the resources of the community are so used to subserve the good of the community. So that is Article 39 B and C. And when I talked about socialism being introduced in the preamble by 42nd Amendment Act, Article 39 B and C already had that concept of socialism, of distribution of material resources and prevention of concentration of economic wealth in few hands. That's the concept of socialism. So if you want to study more about socialism, Article 39 B and C, and the socialism concept introduced by the preamble. So that was always there in the Constitution, which is brought in forefront in the preamble. Then there are directive principles like Uniform Civil Code, basic living conditions for workers, the provision, maternity provision for women, the welfare of children, protection of environment, etc. Then participation of workers in management of the associations or the companies or the organizations, equal pay for equal work. These are various directive principles of state policy which are enshrined in Part 4 of the Constitution. Now, little legal issue. What is important between directive principles and fundamental rights? Because directive principles are not enforceable in court of law like fundamental rights. You can go to court and say that a fundamental right, my fundamental right is violated. You cannot go to court and say that, look, there is a provision that state shall make uniform civil code, so direct state to make uniform civil code. That you cannot do because it is not enforceable in law. That's the difference between directive principles and state and the fundamental rights. However, Article 38 says, nonetheless, the directive principle shall be fundamental in governance of the country. Now, I forgot to mention one important article in the fundamental rights, is Article 21A, which was introduced to provide for right of free and compulsory education to children up to age of 14. Now, to enforce that right, there is a Right to Education Act that is made pursuant to the mandate of Article 21A. That also you should remember, because that's a very, very important article, right to free and compulsory education under Article 21A. I was discussing about what is important, what is critical between fundamental rights and directive principles. The Supreme Court has held in the celebrated case in Keswanand Bharti, which I will discuss in little detail when I deal with the amendments of the Constitution, has said that the balance between fundamental rights and directive principles is one of the basic features of the Constitution. So you cannot say that directive principles are more important or fundamental rights are more important. They both are important, and the state has to strike a balance between directive principles and fundamental rights. And that's the basic structure. So all laws have to be in conformity with both, and legislatures as well as the executive has to strive to make a balance between these two chapters, which are equally important. And that's what the Supreme Court has said in series of judgments. The next chapter which you are supposed to see is the fundamental duties. fundamental duties are provided in Chapter 6 of the Constitution, which is Article 51A. This was not part of the original Constitution. This was introduced by 42nd Amendment Act. There was a committee appointed by the Government of India known as Swarna Singh Committee. Swarna Singh was the minister in Mrs. Gandhi's cabinet in 1975-76. Under his chairmanship, a committee was appointed who recommended that there should be a chapter on directive on the fundamental duties of the citizens, and they were added by way of 42nd Amendment Act in 1976 by Chapter 5A. This is one chapter you must remember by heart because it's a very short one. It has A to K sub-articles, and they provide the duties of the citizens, which are like to abide by the Constitution, respect national flag, national anthem, cherish and the noble ideas which inspired the Indian national struggle, to uphold sovereignty and integrity of India, to develop scientific temper, etc. There are series of them, you should remember them. And that's an important, of course, they are again not enforceable. Nobody can go to court against anyone to say that so-and-so is not following his fundamental duty, etc. They are ideal. The citizens are expected to comply with those fundamental duties, but that's again like a moral obligation of citizens. So you need to remember, you should remember all the duties in Chapter 4A, which is only one article, Article 51A, as I mentioned, and there are duties which are enumerated as A to K. So that's the next topic which you are which is part of your curriculum. Now the next two important topics, which are in the sense we have at the federal government, the central government, which is union of states, and we have states at the local level, and they have their own governments. Of course, there is one important difference, like a difference between our union, our federal structure, and the American federal structure. In our country, the central government is the strong government under the Constitution, and the state governments are not subservient, but the state government's powers can be taken over by the central government under certain circumstances in accordance with the Constitution. Unlike that, in the then this is one important point, that insofar as the distribution of legislative power is concerned, the residuary power vests with the central government. Unlike that, in US, the residuary power of legislation vests with the state government and not with the federal government. So what is our federal and state government structure? The state consists of three organs. The first organ is executive, second is legislature, and the third is judiciary. These are three organs of the state. And one of the directive principles is in Article 50, is that the state shall endeavor to separate executive from judiciary. That is one of the directive principles of state policy. So we have these three organs at both state as well as central level. At central level, the executive consists of Parliament, executive consists of President of India as the head of the government, and the Council of Ministers with Prime Minister as its head, to aid and advise the President of India. So every decision of the federal government is in the name and style of President of India. But President of India does not have the actual powers. It's a President of India is a titular head, as it is known as. The real powers are with the Council of Ministers. Council of Ministers is headed by Prime Minister, and that advises the President of India. So that's the executive structure. So the president is elected by electoral college consisting of all elected members of Lok Sabha, elected members of Rajya Sabha, and elected members of all state legislative assemblies and legislative councils. So that's the electoral college which elects the President of India. The Lok Sabha is elected directly by the people. in their 543 constituencies. The majority party, the party which gets majority in Lok Sabha is entitled to form the government, and that government consists of Prime Minister and the cabinet and the ministers of his cabinet who aid and advise the President of India. So we have an elected Lok Sabha, indirectly elected Rajya Sabha, and the President. So that is the Union Executive. The Union Parliament consists of two houses, that is known as bicameral house, which is Lok Sabha and Rajya Sabha. And as I mentioned, Lok Sabha consists of directly elected 543 members from 543 constituencies. The constituencies are distributed amongst the states on the basis of population, and that population exercise, the reconfiguration of constituencies, that is known as delimitation exercise, that is required to be undertaken after every census. But as of now, the constitution has frozen the constituencies to 1971 census. So therefore, you would be hearing debate on the delimitation being undertaken, the number of seats of each house, number of seats each state as in the Lok Sabha should be rearranged as per the current population, etc. So that debate is going on. But as of today, Lok Sabha consists of 543 members, which are distributed amongst the states. Lok Sabha, the Rajya Sabha is also elected by the state legislative assembly. So they are representatives of the state, and that's not a direct election. So these are the two houses of parliament, and they function as bicameral house. In so far as my financial powers are concerned, in respect of what is known in the constitutional parlance as money bill, Lok Sabha has primacy, because you are dealing with the taxes collected and monies in the hands of the government. So representatives of the people should have primacy and primary say in deciding how to spend this money. And Rajya Sabha doesn't have any say. Rajya Sabha can be overruled by Lok Sabha. Rajya Sabha can only give suggestions to the Lok Sabha in respect of money bills. So money bill is passed by Lok Sabha, it is sent to Rajya Sabha for approval. Rajya Sabha can only give suggestions. Even if they disapprove it, it still doesn't matter. Money bill has a primacy in Lok Sabha. All other bills are required to be passed by both houses of parliament. And after the bills are passed, they are submitted to the president for his assent. The president also has a legislative power to issue ordinances. So when parliament is not in session, president can actually make a law which is known as ordinance. Of course, the ordinance has life till about 6 weeks after the meeting of the Lok Sabha and Rajya Sabha. If it is not approved in Lok Sabha and Rajya Sabha, the ordinance lapses. If it is passed, then it becomes into an act in terms of what is passed by the Lok Sabha and Rajya Sabha as an act. So that's the procedure of making laws in parliament. The third wing of the state at the union level is the Supreme Court of India. Supreme Court of India consists of 34 judges and Chief Justice of India. And possibly all of you know that currently Supreme Court has no vacancy. Supreme Court perhaps has only one vacancy, which has been very, very important site, very rare site that Supreme Court doesn't have too many vacancies. And Supreme Court has 3 or 4 jurisdictions. The first is original jurisdiction, and there are 3 or 4 species of original jurisdiction. The first and foremost is to entertain writ petitions under Article 32 for enforcement of fundamental rights. That's the first original jurisdiction of Supreme Court. The other original jurisdiction of Supreme Court is under Article 131 to entertain what is known as federal disputes between a state and between 2 states, or between states and union and some states on one hand and some other states on other hand. These are the disputes which are known as federal disputes. So for example, there is a suit pending in Supreme Court between state of Maharashtra and Karnataka about the boundary in districts of Belgaum, Dharwad, Nipani, etc. So that's a federal dispute, and that it is pending in the Supreme Court under Article 131 of the Constitution of India. Supreme Court also has advisory jurisdiction to give advice to President of India. You cannot go to Supreme Court. I cannot go to Supreme Court seeking advice. Only President of India can go to Supreme Court of India and seek advice only on constitutional or legal issues, which according to the President require opinion of the Supreme Court of India. And so far, about from 1950, about 12 cases, the Supreme Court has given advisory opinion under Article 143 of the Constitution of India. Then Supreme Court also has original jurisdiction in respect of interstate river water disputes. So that's also original jurisdiction of the Supreme Court. Then Supreme Court of course has appellate jurisdiction to entertain appeals against the orders of any high court or any tribunal in the country. And the law laid down by the Supreme Court is law of the land in terms of Article 141. So that's broadly the jurisdiction of the Supreme Court. Now that is about the union. Now, in so far as state is concerned, we have exactly mirror provisions. So when I told you about the President of India, it is governor in the state. Governor, of course, is not elected like the president. Governor is appointed by the President of India. And in recent years, you must have been hearing about the roles of the governor, whether governor as an institution should be retained or not, how the governor should be appointed, etc. So that's the governor, but governor exactly does the same functions as the president does at the central level. At state level also, we have the three wings of the government, that is executive, which is headed by the governor, with the chief minister and council of ministers to aid and advise the governor of the state. So that's the executive. We have legislature, which consists of legislative assembly, and some states, not all states, have legislative council, that is Vidhan Parishad, which we call in Maharashtra. So they can be bicameral houses, they can be unicameral houses. Several states have only unicameral houses. Maharashtra has two houses, that is Legislative Assembly and Legislative Council. The members of Legislative Assembly in Maharashtra, there are 288. They are directly elected by the people in their constituencies. The constituencies are again framed district-wise on the basis of 1971 population, 1971 census. The Legislative Council members are not directly elected. They are indirectly elected from various electoral colleges like the local self-government. The Legislative Assembly elects few members. Then there are various constituencies like graduates constituency, teachers constituencies, etc. Local self-government, etc. So that is how legislative, and there are of course nominated members, 12 nominated members in Legislative Council. That's how the Legislative Council is, Legislative consists of. Same provision as in respect of money bills. Legislative Assembly has primacy in cases of money bills. Legislative Council can only give advice in respect of money bills. In respect of all other bills, both houses must pass a resolution. Once that, the bill, moment bill is passed, it is presented to the governor for his assent, and governor has three choices. Governor can assent that bill, governor can send that bill back to the Legislative Assembly for reconsideration, or governor can reserve it for president's assent and send it to the president. So these are the three options which the governor has. Once the Legislative Assembly repasses the bill, reconfirms the bill and sends it to the governor, governor is bound to approve that, bound to assent that bill a second time. So that's the executive and legislative process. Governor also has a legislative power of issuing ordinances under Article 213 in cases where the legislative houses are not in session and there is an emergent situation which warrants, necessitates a passing of a law, governor can promulgate an ordinance. That ordinance remains valid for 6 weeks after the assembly meets. Assembly can either pass that law, revoke that law, or modify that law, and whatever assembly does becomes final post passing of that law, post meeting of the assembly insofar as the ordinance is concerned. So that's the legislative power of the state legislatures. The third wing of the state is the high courts for the state. High courts consist of Chief Justice of the High Court and the judges. All these judges are appointed by the President of India. Now, of course, there is a lot of debate, and you possibly might have a question: how is the High Court judge appointed? A high qualification for appointment of a High Court judge is that he should be either practicing advocate for a period of 10 years, or he has been a judge of the subordinate judiciary, or and on that basis, the appointment is made. Now, the normal procedure is the Supreme Court in the judge's case has confirmed that procedure is of the Collegium of the Supreme Court. So the recommendations for appointment of High Court are made by the Collegium of the Supreme Court on the basis of recommendations of the High Court, and the President of India issues warrants for appointment of the High Court judges. The High Court judges hold office till age of 62. The Supreme Court judges hold office till age of 65. Now, that difference of age has been traditionally recorded. There has been debate about that, but that's how the retirement age as of today is. So that is the composition of High Court. The jurisdiction, High Court has various jurisdictions. Now, first and foremost, an important jurisdiction of the High Court is extraordinary jurisdiction under Article 226 of the Constitution of India, which is popularly known as writ jurisdiction. Under this article, High Court can issue orders, directions, or writs in the nature of the 5 writs: the writ of habeas corpus, writ of mandamus, writ of prohibition, writ of quo warranto, and writ of certiorari. So these are the 5 writs. Now, for you, you don't need not worry about the details of these writs, but these are the 5 writs which the High Court can issue in various circumstances. That's the important jurisdiction of the High Court, which is the original jurisdiction of the High Court. Another important jurisdiction of the High Court is under Article 227, which is superintendence over subordinate courts. Now, when you become some of you will become the members of the State Consumer Redressal Forum and District Forum, etc. Both these forums would be subordinate tribunals to the High Court, and these forums are subject to High Court's superintending jurisdiction under Article 227 of the Constitution of India. Though, of course, there is an appeal from State Consumer Forum to the National Consumer Forum, the High Court can always entertain a writ petition under Article 226 or 227, because the High Court's jurisdiction under Article 226 cannot be taken away by any constitutional amendment also. So these are subordinate. Of course, normally the other courts like Civil Judge Junior Division, Civil Judge Senior Division, and District Court, these are the properly constituted courts. They all are subordinate to High Courts, and their orders can be questioned in High Court under Article 227 in power of superintendence. There is, of course, an appellate jurisdiction of the High Court properly constituted against the orders of the subordinate courts. There is a regular appeal provided to the High Court, first appeal or second appeal as the case may be. That's another jurisdiction of the High Court. In Mumbai, High Court has, of course, additionally original jurisdiction, which original jurisdiction is conferred only in India only on 4 High Courts, that is Mumbai, Delhi, and Mumbai, Madras, and Calcutta, which are known as chartered High Courts, which were established in 1861 with the original jurisdiction. And that jurisdiction continues. Original jurisdiction means you can file a civil suit also in these 3 High Courts. Additionally, Delhi High Court also has original jurisdiction. So apart from these 4 High Courts, no other High Court has civil original jurisdiction to entertain civil suits. All such civil suits in all other places must be filed in the lowest court, that is Civil Judge Junior Division, or depending on the pecuniary jurisdiction. But the High Court in Mumbai has original civil jurisdiction. In addition to that, High Court also has various jurisdictions such as insolvency jurisdiction, admiralty jurisdiction, company jurisdiction, adoption matters, wardians and guards, etc. So these are various jurisdictions which are conferred upon the High Court under various acts, and the jurisdiction under the Constitution are the 2 jurisdictions which I mentioned under Article 226 and 227. Under Article 228, the subordinate courts can refer questions of law to the High Court on which they want assistance in interpretation of law. So that also can be referred to the High Court. The High Court has entire power of superintendence over the subordinate judiciary, not only in judicial matter, but in administrative matters also. The appointment of the subordinate courts can be made only on the recommendations and in concurrence of the High Court by the governor of the state. So that's an important aspect in preserving independence of the judiciary, because as long as you provide for the independence of the judiciary, then the democracy is safe. Because you cannot have intermixing of the functioning of the executive and the judiciary, because that is mandate of the constitution. One important thing, insofar as both High Court judges and Supreme Court judges are concerned, their salaries are charged on what is known as Consolidated Fund of India, insofar as Supreme Court is concerned, and Consolidated Fund of the state. What this means really is, there is no requirement of passing of a bill in the assembly or in the parliament for making provision for payment of High Court judges or Supreme Court judges' salary. It is a charge on consolidated fund. So whether a bill is passed or not, their salaries would be paid. This is yet another important facet for providing independence of the judiciary. So if you are asked a question about features of independence of judiciary, there are three. One is that there is a fixed tenure. Second, their salaries are charged on consolidated fund. And three, which is very, very critical, they cannot be removed from their office unless a procedure for impeachment is adopted. An impeachment procedure means a motion has to be moved in one house of parliament with the requisite numbers. Then a committee is appointed under the Judges Inquiry Act committee. That committee has to hear that particular judge, and on that basis, a report has to be made, recommendations have been made. And if that committee recommends removal of the judge, that report is submitted again to the parliament, and parliament has to pass a resolution in both houses removing the judge. And if such an impeachment resolution is passed, then only a High Court or a Supreme Court judge can be removed from his office. So far in India, from 1950, no judge has been removed by way of impeachment by the parliament. So far, there have been about 4 occasions where impeachment motions were moved in the parliament in respect of a High Court and Supreme Court judges. So that's broadly about the union and the states. Now, 2 more important topics, which are panchayats and municipalities. Panchayat is under Chapter 9, which is local self-government. Now, that's an important aspect you need to remember. Local self-government has been given a statutory recognition in Chapter 9 in case of Panchayat, which was introduced by 73rd Amendment Act in 1992, and Chapter 9A in case of municipalities, which was introduced by 74th Amendment Act in 1993. So Panchayat consists of 3 levels. One is at village level, which is known as Gram Sabha. Then there is an intermediate level, which most of you would remember as Taluka Panchayat, and at the district level, which is the Jilla Parishad. So these are the 3-tier local self-government panchayat, which is now mandated. Maharashtra already had this procedure, had these provisions even before this constitutional amendment came into force, but now it has been given a proper statutory recognition. So what these provide is that state must have these 3-level panchayats as a local self-government. They all must be elected bodies, and they have powers in financial matters as well as administrative matters. And that's why there is so much development work which is undertaken at these 3 levels, Gram Sabha, Taluka Panchayat, and District Panchayat, which is established under Part 9 of the Constitution. So that's broadly about the panchayats which are established under Part 9. The municipalities are established under Part 9A. So in addition to the existing municipalities, the Constitution now provides that for a particular population, a municipality can be established. The Constitution also says that the state can make law and provide for powers of the municipalities, municipal planning committee, planning matters, taxation matters. They all can be provided, and the powers can be conferred upon the municipalities under the law which has to be made. So 2 important things about panchayats and municipalities you need to remember is These are required to be established. They can be established by a law to be made by the state legislature, and that state legislative law must provide what the powers, authorities in respect of administration and taxation of panchayat and municipalities are concerned. The last topic is in respect of amendment of the constitution, that is part 20, that is article 368. It has a huge checkered history. The original article 368 was headed by, its heading was procedure for amendment of the constitution. So it only provided a procedure that a bill may be introduced in parliament, and it has to be passed by the specified majority, 2/3 majority of the members present and voting in both houses. So then constitution amendment bill is passed. However, if the bill of constitutional amendment relates to the powers of the state, the high courts, the legislative distribution of the powers, etc., then more than half state assemblies need to ratify that constitutional amendment bill. That was the normal procedure of constitutional amendment, and there was no issue about the amendment of the constitution from 1950 to 1967. In 1967, Supreme Court in Golaknath case said that a law under Article 13 would include Constitutional Amendment Act. And Article 13 says that you cannot pass a law which will violate fundamental rights under Part 3. So obviously you cannot delete a fundamental right. So the Supreme Court said that while you can amend the Constitution, you cannot touch fundamental rights because that will be contrary to Article 13. That gave rise to huge issue, and the Constitution was amended. They amended the title of Article 368 to say power of Parliament to amend the Constitution and procedure thereof. And they said a Constitutional Amendment Act will not be considered as a law for Article 13. And they added a clarification that for removal of doubts, Constitution can be amended, including any part thereof by way of addition, alteration, amendment, substitution, etc., including fundamental rights. This was challenged in Supreme Court, and the Supreme Court constituted the largest ever bench in Keswanand Bharti case in 1972-73. And in 73 April, we celebrated 50 years of Keswanand Bharti case this year. And in April 1973, Supreme Court by majority of 7-6 held that Constitution can be amended. Any part of Constitution can be amended, including fundamental rights. Fundamental right can be deleted. The only limitation on the power of Parliament to amend the Constitution is it cannot alter, damage, or destroy the basic structure of the Constitution. So that's the doctrine which was evolved by the Supreme Court in Keswanand Bharti case. Since then, there have been series of decisions of High Court as well as Supreme Court in which they have laid down what facets of Constitution are considered as basic features of the Constitution. So I told you earlier, balance between directive principles of state policy and fundamental right is one of the basic feature. Free and fair elections is a basic feature of Constitution. Rule of law is a basic feature. Independence of judiciary is basic feature. Free and fair elections is a basic feature. Then essence of fundamental rights is a basic feature. A democratic republic, a democratic government is basic feature of the Constitution. So the Supreme Court has ruled various features. So whenever issue arises, whether a particular facet is a basic feature or not, whether particular law, Constitutional Amendment Act offends the basic structure or not, is considered by the Supreme Court with reference to Keswanand Bharti's case. In so far as the legislative relations between union and state is concerned, I omitted to mention Article 246 of the Constitution provides the legislative powers distribution between union and states. We have Schedule 7, which has 3 lists, which is known as state list, union list, state list, and concurrent list. State list is the union list is the subject on which only Parliament can legislate. State list is the subject on which only state legislatures can legislate, and concurrent list is the list on the subjects on which both parliament as well as state legislatures can legislate. So that's the legislative distribution of powers between union parliament, that is Lok Sabha, Rajya Sabha, that is Sansad as we call it, and the state legislature. There are, of course, rules under Article 254. What happens if there is a conflict between a law passed by the state and central government on concurrent list subject? The central law will prevail. If the state law gets presidential assent, the state law will prevail, etc. How to divide this, how to decide whether a law is on a particular subject on a state list or concurrent list? The Supreme Court has evolved a doctrine known as pith and substance. So you will look at what is the pith and substance of the law to find out whether a law relates to state subject or central subject, etc. And on that basis, the issues are decided. And finally, the residuary power of legislation, if the subject is not enumerated in any of the lists, then that power vests in parliament. So that's broadly the distribution of legislative power, and that broadly covers the topics which you are supposed to be familiar with for your ensuing examination. So I wish you all the best for your future career and all your endeavors. If there are any questions, I can take those. Thank you.
Good evening, sir. I have one question.
Go ahead, go ahead.
Sir, the liberty which is mentioned under Article 21 and freedom which are guaranteed under 19, is there any similarity between these two words, liberty and freedom, or we have to see in different contexts?
Sorry. Freedoms guaranteed under Article 19 are 6 freedoms which are positive rights. They are available only for citizens. So you can enforce that. Like you have a freedom to carry on trade on business. Freedom means you are not bound to do it. But if you do it, you will not be stopped by anybody. So that's your freedom. As against that, liberty is conferred upon everybody. Personal liberty is available to everybody. And personal liberty includes everything. You can go to court, ask for it, enforce it. That's the distinction.
Thank you, sir.
Thank you very much, sir. First of all, on behalf of Bar Council of Maharashtra and Goa, I extend sincere thanks to Advocate Dr. Milind Sathe sir for enlightening us on the topic of Constitution of India. And special thanks to Advocate Dr. Milind Sathe sir for preparing notes for the participants by sparing his valuable time. Thank you very much, sir.
Thank you.
Now the announcement for the participants that the notes prepared by Advocate Dr. Milind Sathe sir will be sent on their email address, which was given in the Google form. I express my sincere thanks to our coordinator of this lecture series, Advocate Dr. Uday Varunjikar sir, as well as the chairman of our BCMG, as well as vice chairman of the BCMG. Moreover, now today, our one of the member, that Advocate Amol Sawant sir, is there in the Zoom meeting. I express my sincere thanks to Advocate Amol Sawant sir also. And lastly, thanks to all the participants who has made this series successful. Thank you very much. Now, announcement for tomorrow's lecture. Tomorrow, the lecture will be of Honorable Sri Justice Surendra Davde, former judge, Bombay High Court, and now the President of Maharashtra State Consumer Dispute Redressal Commission. So be connected tomorrow also by 6 p.m. Thank you very much.